Amen.
All right, good morning to all. Pardon my just getting started, we got behind a little bit here. This is case number 21-150642. This is Image Therapeutic Care LLC versus City of Detroit. But that is before the court on an adjourned final pretrial conference date. Apparently, the parties had spoke about facilitation in this matter. Your appearance for the plaintiff, please. I have Image Therapeutic. Let me hear from the city of Detroit, if you will.
Yes, Your Honor, Joel Ashton appearing for the city on this case. I'm aware that plaintiff attorney is out of town and he possibly won't be signing on this morning, but I can report on our status.
All right. Thank you, Counsel. Just indicate your B number, if you will, for the records.
Yes, 47039.
Thank you, Mr. Ashton. Mr. Ashton, thank you for updating us relative to plaintiff's counsel being out of town. Update me on the status of things here. I know that there was talk of trying to get this facilitated. What's going on at this time, sir?
That's correct, Your Honor. We just facilitated this case last week. We have a tentative settlement of $8,950. We need to have that approved by City Council. At this point in time, I'm not sure if we'll get it on their agenda for January, so it's possible it may not go before them until February.
All right. So, Counsel, what I'm going to do, I have an order that I issue in such matters that will indicate that the case is conditionally dismissed where the matter is pending before a public body for approval. If the matter is approved, the funds are dispersed in the case, the dismissal will be with prejudice. If for some reason there is a failure in that process, the case may be automatically reinstated by the plaintiff. I will issue such an order. You'll receive a copy, and the other side will receive a copy as well. And I do wish both sides well, of course, in getting to the finish line.
Very good.
All right. Thank you, Mr. Ashton. Good day to you, sir.
Thank you, Judge. You too.
The court now calls case number 21-160736. This is Complete Imaging versus City of Detroit. The matter is before the court, set on for a pretrial conference. The court previously, I believe, issued an order of discovery in this matter. Let me get your appearance on this matter for the plaintiff. It looks like this is the same plaintiff in the other case, same attorney. Let me see the City of Detroit, your appearance.
Yes, Your Honor. Michael Lawton, P81884, be appearing on behalf of the City of Detroit. Plaintiff's attorney, I saw him initially this morning and now I don't see him on here. So this is a second pretrial, our first pretrial set. Discovery, the city right now is waiting on responses from plaintiff. But we've been moving along in this case, just need a little more time.
Sounds good. So should I review it in about 30 days? That makes sense to you?
That would work for me, Your Honor.
All right, so I'm going to, I'll set what's in the nature of a final pretrial conference some 30 days hence, a specific date. My clerk's going to give it to us in just a moment here. And I'll take a look at everything at that time.
26, January 26.
1/26/22, and that's going to be at 9:30 a.m. And an order will be issued with that specific date and time on it as well.
Thank you, Your Honor. If we don't have discovery responses by then, can we file a motion to be heard on that date as long as it's filed with enough notice?
Yeah, as long as it's filed and it gives the other side at least 7 days to respond.
Okay.
You could set the motion for hearing on the 26th. Just make sure you give us 7 days to respond.
Okay.
And,
thank you, Your Honor.
court now is calling case number 21-164193. This is Lospec RX LLC versus Indian Harbor Insurance Company. The matter is before the court, set on for hearing. I think this is the first hearing after the joining of this matter. All right, your appearance for the plaintiff in this matter.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff P84581.
All right, and good morning to you, Ms. Collier. And it looks like this is, I see some initial disclosures, et cetera, for the plaintiff in this, for the defendant in this matter, please.
Morning, Your Honor. Brian James on behalf of defendant Indian Harbor P82226.
Thank you, Mr. James. And I do see the plaintiff's initial disclosure regarding this matter. Looks like you're just getting started with this case. That's about the size of Mr. James.
Yes, that's correct, Your Honor. We actually didn't receive notice from the court for today's appearance either. Opposing counsel that was kind enough to contact me to appear here this morning. So I don't know what happened with receiving any notices on that as well.
Got it. So we've got you at the Bridge Streets, Northwest 333 in Grand Rapids. Is that correct location?
Yes, 333 Bridge Street. Is that what you said, Your Honor?
Yeah, Northwest 333 Bridge Street, Northwest Suite 530, Grand Rapids 49504.
Yes, that's correct, Your Honor. I'm not sure what happened then.
All right, well, we'll do our best to make sure that things are corrected. Sometimes what happens is it goes out to Indian Trail Harbor Insurance. That might, so we'll make sure that it gets to you. That's why I was checking on your address. All right.
Yeah, I appreciate that. Thank you.
So, Ms. Coley, what needs to happen in this? I know that you've already done your initial disclosures. How much discovery do you think might be needed in either side to speak as to this issue?
Your Honor, plaintiff does not need discovery time. However, I believe opposing counsel did indicate that they do. So I believe 60 days is fine if that's okay with defense counsel.
Yeah, I would like to conduct a little bit of discovery in the case if we could. I would request 90 but 60 is fine as well too if we're trying to keep things going a little faster. I just don't want to hit bumps in the road and need to transition later. But
All right, so it sounds like a case where I'll go ahead and set it on for 60 days. As long as the parties are moving along and you try and do what you have to do. If it turns out that you need a bit more time, then I generally can't grant a bit more time as long as the case is moving. If something else comes about, I'll allow discovery to continue. So what I'm going to do is I'm going to set a pretrial conference date some 60 days hence. Just one moment here. That's going to put us in February. So I'm going to set a return date on this of February 23rd, 2/23/22. In fact, why don't I go ahead and put that for the 28th? That's going to be 2/28/22 at 9:30. Discovery may continue through that date. Also, the parties may file motions to be heard on that date, February 28, 2022. So long as the parties allow at least 7 days notice for the opposing party to respond to the motion, I will hear it on the 28th. So that could be a dispositive motion. It could be non-dispositive. There's some motion you need wish to bring before the court. The time periods are being short. Grant, you must provide at least 7 days notice to the other party to give them an opportunity to respond, and just go ahead and set it on the 28th. I will do it.
All right. Thank you, Your Honor.
okay, thank you, Your Honor.
We'll see you at that time. I wish you all happy holidays.
Likewise,
too,
Your Honor.
thank you.
Thank you very much. And Helen, if you could, I see your message there. Never mind. Thanks.
All right. I'll email you.
Sounds good. Bye, everyone.
I'll do. case number 21-164457. This is Credit Acceptance Corporation versus Tynetra Burns. The matter is before the court, set on for a general hearing. This is regarding a matter where there has been an answer filed. This is the first hearing after the filing of the answer in this matter, so I have set it for a status conference. For the plaintiff in this matter, your appearance at this time, counsel.
Judge, may I please court? My name is Attorney Richard Rusin. For the record, my bar number is 35222. I'm the attorney of record for the plaintiff.
Thank you, Mr. Rosen, and good morning to you, sir.
Hi.
I'm now looking for Counsel Burns or Ms. Burns. If you're on this record, say something at this time, please.
Good morning. I'm Tanisha Burns.
All right. Thank you, Ms. Burns, and good morning to you, ma'am. I see that this looks like a complaint alleging contractual indebtedness in excess of $6,000, which includes $1,400 in interest. This seems to relate back to an installment contract. Looks like this was for the purchase of a vehicle. All right, so Ms. Burns, what is your just give me some sense of what your challenge is with regard to this alleged indebtedness, ma'am.
Yes, I had purchased the vehicle a number of years ago, but it was in an accident a couple of years ago, and I thought the insurance company paid the vehicle off. I was unaware that it was still a balance owed.
Right. Mr. Rosen, can you update us on what happened? If you have any information regarding any portion that may have been paid by an insurance agency, any information, sir?
Yes, Judge, I'll be brief in about 90 seconds. It is true, this is on a car note deficiency balance. The car was apparently in an automobile accident, as defendant alludes. She was insured by Geico Indemnity Company, and the insurance company did in fact pay the gap insurance. And I'm looking at, in my hand, a letter dated May 8th, 2019 from Geico to Ms. Burns, giving her what was called a total loss settlement explanation. What happened was that they paid $4,000. Oh, I'm sorry, that they paid on their insurance, but unfortunately it left a balance due on the car note. And that's what this is about. I believe, Judge, that a little discovery may go a long way. I would ask for 60-day discovery, and I will be, during that discovery, if you grant it, sending to Ms. Burns all the documentation that I have from the Geico company, as well as the credit acceptance company that went to her. Matter of fact, I'm looking at a May 8th, 2019 letter from credit acceptance to Ms. Burns advising her of what the deficiency was after the total loss of her insured vehicle.
All right, very well. So it looks like, Ms. Burns, that there may be some accounting issues that is part of this to connect the dots in terms of what was the balance at the time that the car was totaled, what insurance paid, and what the deficiency balance might be in regard to this matter. Counsel has asked for the court to allow a formal process that is called discovery to take place. And that is a period of time wherein the parties can submit questions to the other side, ask for documents, et cetera, and the other side mutually are responsible to submit documents and respond to questions during that period of time. That may greatly assist in regard to this matter because it will allow the presentation of the documents that either support the debt or establish that the debt should not be what it is alleged to be. So I'm going to go ahead and set it on a 60-day discovery track. That means that the next time that this case will be up and be heard in front of me will be on 28th February, 2/28/22, and that's going to be at 9:45 a.m. February 22nd, February 28th, 2022 at 9:45 a.m. A notice will be generated that will be sent to your home address. During that period of time, Ms. Burns, you may request documents from Mr. Ruzin's office. Mr. Ruzin has indicated that he will send the document packages that he has. But if there's other information, questions that you have, you can put them in written form and submit them to his office, and they will respond to those to your inquiry. They may also send you documents of questions, requests to admit things, et cetera, and you're required by law to respond to the documents that they send you, just as they are required to respond to documents or questions or inquiries that you may make to his office. So the next time that I see your this case before me will be on the 28th of February 2022. So I do wish both sides well, and I'll see you at that time.
All right, thanks, Judge.
Any questions?
Is it possible to try address here or change it directly with the attorney?
You talking about your address?
Yes, for all of the documents to make sure that it's gonna come to the address that I would like it to come to.
Okay, so you're breaking up a little bit. The address that I have, I won't get the whole address, but it's at Riverfront, apartment 808. Is that the correct address?
That is a legitimate address, but I would like to change the mailing address for this paperwork, if that's possible.
All right, so what I'm gonna ask that you do, ma'am, I'm gonna ask that you put it in the chat so that we can
Okay.
update the file regarding the address that you wish to use. So just chat it, and if you would chat it to myself as well as to Mr. Ruzin, that would make things substantially easy. You understand?
Yes,
All right, thank you.
thank
ma'am.
you.
And Mr. Ruzin, if you don't get it right away, when we send the notice out, the new notice will have the updated address on.
That'll be just great. That'll be just swell. All right, thank you.
Thank you. Good day to you, sir. Good day, ma'am.
Bye-bye.
Thank you.
All right, the court calls case number 21-152874. This is Biomolecular Integrations Incorporated versus Allstate Insurance. The matter is before the court, set for a general hearing on today's day. Looked like there was a default or something entered at some point. Let's get your appearance on the record for Biomolecular, please.
Your Honor, I noticed that Miss Cooley was on earlier, but she logged off. I tried to give her a call, but I didn't receive a response.
Let's get your appearance on the record, Madam Counsel.
Okay, Denasia Neal, P83076 on behalf of Allstate.
Thank you, Ms. Neal, and good morning to you, ma'am.
Good morning. Your-
So what's, I don't know where opposing counsel escaped to. What's happening in this file? Give me something of an update.
So actually, we are planning to take the deposition of the biller and the ordering doctor in the patient suit, but the biller in his suit. And we are filing a motion for summary disposition in the EIP suit, so we just need a little more time. To get these things situated.
Get things moving along there. All right.
Yes.
So did I set a discovery order in this case
Um,
already?
We haven't received one.
All right. So what, let's see what I did here. Just one second.
Well, we did, but it was blank.
Oh, you received the form. Gotcha. All right, so what I'm going to do, Ms. Neal, I'll go ahead and set a 60-day discovery window on this. And I'll bring it back on the 28th at 10 o'clock a.m., February 28th, 2/28.
At 10 o'clock.
And and I'm going, and you'll get an order from me with those, with the dates and what have you. So that's 2/28/22 at 10:00 a.m. is the pretrial conference regarding this matter. I am allowing discovery through that date. I'm also allowing for the setting of motions for hearing on that date as well. You may file dispositive and or non-dispositive motions on that date, the second for hearing on that date, 28th of February, so long as you allow at least 7 days for the other side to respond to the motion that you. So you'll get a scheduling order from me with that same information contained therein. All right. Any other thing you need to bring to my attention? Any other questions at this time?
No, thank you, Your Honor.
Thank you. Good day to you and happy holidays to you.
Same to you.
All right, this is case number 141233. This is Auto Club Group versus Latanya Garrett. The matter is before the court, set on for a motion hearing on today's date. The record should reflect in this matter that the court issued an order on the 21st of July requiring monthly payments on a judgment that was previously entered in the amount of $100 per month. I received a motion on the 21st of December that said that the judgment was paid in full on 10/26/21. And when I received that, I took the matter under advisement and set it on for hearing on today's date. All right, let's see. Do I have anyone from Auto Club Group on the Zoom? If you are, please give me your appearance at this time. All right, do I have Ms. Garrett on this Zoom? Say something if you hear Ms. Garrett.
I am present, Your Honor.
All right, good morning to you, ma'am.
Good morning.
All right, so looks like the other side was notified by this court to be here regarding this matter today. And so when I saw that you indicated that you paid in full, and this was one of those situations where you said something about a business license and something was being interfered with because of this. Talk to me a bit.
I'm sorry, I couldn't hear the last part, Your Honor. Something about a business license.
All right, you put something in. Yeah, all that bass in my voice. Anyway, you put something in your motion that says something about this was interfering with your business license or something. So I said, go ahead and talk to me. Tell me what you're talking about.
Well, no, not a business license, just being able to conduct my daily business. This was an unfortunate situation where it was not me that hit a plaintiff, and unfortunately I was sued. I gave the car to my husband and he loaned it out, and the person that was driving did report to the police that they were driving, but unfortunately because my name had not been taken off the car, I was sued. But moving forward, I did pay 3 installments, and then my husband went on and paid the balance for me off. I spoke with the plaintiffs, and because they are a debt collecting firm, they could not give me any information. But what they did say that once I paid it off, it will only take up to 18 days for me to receive a satisfaction of judgment. And I have not received that, and they will not take any more calls from me. And I am in a bind trying to get employment, and I can't. I need my license for the jobs that I am applying for.
Gotcha. So they did a financial responsibility suspension on your driver's license. That's what you were talking about, correct?
Yes. And if the debt is not paid off, I also had to have a SR22 connected to my license, which the insurance was extremely high if I needed that SR22. So that's why we paid it off.
That's one of the pressures that come with the financial responsibility law that allows for that license suspension. That's a tough cut. I don't know why they're not getting back to you, that the typical thing is to simply issue a satisfaction of judgment and be done with it. But given that they're not here and nobody has appeared on that side, I will issue an order indicating that the judgment is satisfied. I believe that if there was still some money or obligations that were owed, that somebody from the other side would appear today. We sent a notice to them, they did not appear. So I'm going to issue that order, and if you'll give me an email address, I will have my order emailed to you today so that you can take it and do what you need to do with it.
Yes, thank you so much. I will put the email address in the chat, or do you want me to voice it?
No, go ahead and put it in the chat. You anticipated my next statement. So
Okay,
court is granting your petition for satisfaction of the judgment in this matter. The court deems that the judgment is satisfied based upon competent statements offered by Ms. Garrett, and based on the failure of Auto Club Group to appear in opposition to her petition. All right, so go ahead and chat your email address, and we'll get that out to you today. All right, good day to you.
I have placed it in the chat, Your Honor.
All right, thank you, Ms. Garrett, and I've received it as well. Thank you, ma'am.
Thank you. Happy holidays.
Likewise to you.
Am I free to log off, Your Honor?
Yes, you are, ma'am. Good day to you. I'm just taking down some information. Good day to you. All the best to you and your family.
Okay, thank you. Bye-bye.
Now, when you see, how deep. This is the latest. We have sent a notice out. This is the action.
Okay.
Still.
Oh, okay, all right.
You see how neat that.
Yeah, very neat. Yeah, you did that very neat.
I should have let you know.
Mhm.
But I didn't put it.
Yeah, you got it super neat. Want to notice